A jury has found that Sarah Palin has not been defamed by the New York Times. Now, for those who might not know or remember, since it was a very long time ago, Palin was once a Republican vice presidential candidate and governor of Alaska, and at one point she even hosted her own reality TV show. Mrs. Palin initially filed her lawsuit in 2017. Lawsuit concerned an opinion piece written by James Bennett and published in the New York Times. Title was America's Lethal Politics, which of course I had to immediately read after hearing it was being sued over. So the op-ed addresses the issue of gun violence in the United States and originally stated the following. In 2011, when Jared Lee Loughner opened fire in a supermarket parking lot, grievously wounding Representative Gabby Giffords and killing 6 people, including a 9-year-old girl, the link to political incitement was clear. Before the shooting, Sarah Palin's Political Action Committee circulated a map of targeted electoral districts that put Mrs. Gifford and 19 other Democrats under stylized crosshairs. Now, if you attempt to look up the article, you'll notice that it makes no reference to the words that Palin alleges to be defamatory. And that's because the New York Times corrected the piece within 19 hours after it appeared online and admitted that its wording was flawed. It also issued the following statement on Twitter. We got an important fact wrong, incorrectly linking political incitement in the 2011 shooting of Giffords. No link was ever established. Now, the legal drama in this case is extensive. In her complaint, Palin asserts that the Times falsely asserts that she clearly and directly incited the 2011 assault against Representative Giffords in Arizona. Mrs. Palin alleges that the op-ed defamed her by falsely accusing her of inciting gun violence in the political context. As the complaint alleges, in January 2011, there were a lot of unsubstantiated rumors about a possible connection between Palin and Loughner's crime because of a map posted online which depicted congressional districts that Republicans were targeting for victory in an upcoming election. And 6 years later, after left-wing blogs allegedly all took their political hits against Palin and made numerous jokes about her, the Times fabricated this supposed pattern of politically incited violence against members of Congress, thereby resurrecting a debunked connection between Mrs. Palin's political activities and Loughner's 2011 rampage in Arizona, or so the complaint alleges. So in order to find the Times to be liable for defamation, a jury would have to find that the Times acted with actual malice. In the United States, media defendants enjoy a higher standard of protection in order to protect First Amendment values, right? Freedom of the press, freedom of speech. So a plaintiff in any lawsuit involving a media defendant has to show that the publication knew what they published was false or was so reckless in what they published that it was impossible for any person to possibly believe what was published was true. The district court initially dismissed Palin's case in 2017. Palin then appealed that decision. 2019, Second Circuit Court found that Palin had stated a defamation case. It kicks the case all the way back down to the trial court to be heard. Now remember, Second District Court does not decide the merits of the case. That's for the trial court, the jury to decide. So in February of 2022, jury found that the New York Times was not liable to Palin for defamation. But in a procedural array of mess and technicalities, it should be noted that the trial court dismissed the case, but allowed the jury to reach a verdict. There's this question regarding the extent that the jurors' receipt of push notifications alerting them to the court ruling played a part in their decision to find the Times not liable for defamation. So that, coupled with a bunch of other procedural evidentiary objections, gets appealed by Palin and her legal team to the Second Circuit Court, which vacates the district court's judgment and jury's verdict, citing to an array of procedural and evidentiary errors. So the case is remanded back down to the trial court. Second jury also found that the Times was not liable for defamation in 2025. Now, Palin, after receiving the verdict, posted text that she plans to, quote, keep asking the press to quit making things up.